heart, staring at the sea. It's a hand squeezes all your hopes and dreams. You say you retreat. You say you just can't win before you let the circumstance tell you how sorry God's come. Oh, hey, hey, in the hand. See you getting bad right now. Let me say I know that feeling well. And for life and then watch them take out saying, let me hurt you. This need. But if you speak, so by will all the say, oh, I'm right because I fell down. But I will always receive good. I know. Greetings, greetings, greetings. As it, greetings, 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 greetings. It is I, King Clifford Jefferson, a Senator Godfrey the Fifth Caliban Jew, son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know as Jesus Christ, or the Vicar of Christ, or what we call Malachi Zodok, better known as the King of Righteousness. It is October 7th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of my Queen, Sister Galveston from the House of Galveston. I greet you in the name of my Archbishop Belmont from the House of Belmont. I greet you in the name of all the predecessors, all the successors, all the heirs, all the children, all the mothers, all the fathers, and all those who will be coming into the temple shortly. This is a special lesson given to all those who are truly heirs and who truly understand what it is that they were called to do just as a result of them following instructions. Following instructions. A lot of us have a hard time following instructions. And as a result of that, we find ourselves in the position that we are in now. So this lesson right here that's being done today, the title of it is called Secular Liberalism is a Breach of the King's Peace. Once again, secular liberalism is a breach of the King's peace because politics and religion don't mix. It does not mix. Okay? So once again, the name and the title of this lecture is called Secular Liberalism is a Breach of the King's Peace. All right, I expect all of you who are watching this lesson to take heed. A lot of you really don't understand what it is that we do here at the Third Temple English Church of England. And you must understand the strides that we have taken as a temple to get to where we are at now. And as a result of that, rules and standards and policies had to be implemented for the temple, for the leaders, as well as those who are subjects. And when I say subject, I mean heirs. So this is the letter that was put out by Archbishop Belmont for all subjects supposedly claiming to be heirs. All right, this is a letter that I agreed to, that I looked over, and it was prescribed and had my seal on it. So all those who are unaware of what it is that we do here and are questioning themselves about where they are in this movement, this letter will tell the tale. Because one thing about this movement is that we are intellectual movement. And we're always moving. When we say moving, we mean striving to learn, comprehend our ancestors' way of life, our culture. Okay? So I've done a couple of lessons that I've been putting out the past couple of weeks. And they're drawing a lot of attention. Now, as a result of the attention that they're drawing, a lot of the members who are supposed to be part of the temple are finding themselves at a distance as a result of the teachings that are being taught here at the English Third Temple Church of England. And if you are subject, i.e. an heir, that means that your comprehension of these lessons must be fully comprehended as if it was being played for you or you were watching it at that point in time. So I think a lot of you are discouraged or afraid of the requirement. But as I said before, I did not come to change the law. I come to fulfill the law, as it was in the days of my forefathers. So with that, I'll give a narrative of the letter that was put forth and emailed to all those who claim to be successors. And if you're a successor, that would mean you will be an heir. And if you're an heir, that means you will be a subject. And if you're a subject, that will mean you will be inherited to the laws that are prescribed for us here at the Third Temple English Church of England. So with that, let me get to the syllabus of the letter that Archbishop put out for the members. All those who are inquiring about being the subject, you must report to Archbishop Belmont of the English Third Temple Church of England. There's the list of the emails that were sent, a notification. So if you find your name herein, then it applies to you. Okay? If you find your name here therein, it applies to you. It's not personal, it's business. Okay? The letter was dated October 7th, 2974, which is equivalent to the Gregorian year 2024. Dear members, i.e., subjects, i.e., heirs of the Third Temple English Church of England, we first extend our deepest gratitude to each of you for your contributions and for giving honor to the Creator, our forebearers, and our Christ King Edgar the Peaceful, and our Lord King Clifford Jefferson of the Royal House of Plantagenet, and his Queen, Queen Lisa Jordan, from the House of Galveston, from the Royal House of Galveston, the heirs, successors, officers, trustees, peerage, and all the loyal people within this realm. Your support has been instrumental in our shared journey and rebirth of the Kingdom of England, also known as the Kingdom of God. Progress of the King's Court cases. We are aware that the progression of the King's Court cases has been slowly yet steady. These cases are unlike any that have been seen before, which contributes to the complexity of their resolution. We appreciate your patience as we continue to work diligently through the unprecedented matters. Addressing concerns. We hear your cries and concerns, and we emphasize with the struggles you are facing. However, it is important to understand that the work ahead is not easy, nor does it promise immediate results. Many of us are still grappling with situations we placed ourselves in prior to the return of the English church. Due to our limited resources and time, we must focus on the church as a whole and avoid becoming overwhelmed by individual perspectives. A reminder of our history. The Kingdom of England history stretches back to the House of Wessex, and the rebirth of the kingdom is rooted in the Benedictine intellectual movement. Our laws, instituted by our kings, incorporated the Ten Commandments, the Mosaic Code, and the Christian ethics, which all English heirs are bound to follow. It is a lifestyle we must abide by. Trustees and church structure. The 12 trustees must be appointed by the king, and if you are not ready, you will not be placed in the position of trust. Our church consists of common nobles, lords, and royal family, and your actions and deeds determine your peerage. Moving forward, we are only interested in those that are pure at heart, who can follow directions and in the given instructions. This movement cannot wait on any individual. If you are unable to catch up to the necessary lessons, that is a responsibility you must face alone. I repeat, we are only interested in those that are pure at heart, who can follow directions and the given instructions. This movement cannot wait on any individual. If you are unable to catch up to the necessary lessons, that is a responsibility you must face. Any and all decisions must cease immediately. New Sabbath schedule. For the next 4 weeks, the Sabbath will be observed on Thursday, beginning on October 10th. Please make necessary adjustments. Final reminders. If your paperwork, including name correction, is incomplete and your dissertation is unfinished, you are not a full member of the English Church, now known as the Third Temple English Church of England. Today, all past indifferences will be reset to maintain order within our church. Please ensure that you respond by Wednesday confirming you received of this notice and acknowledging the outlined requirements. We apologize that we cannot assist with individual court matters or other situations due to limited resources. If anyone questions their allegiance, they are free to expatriate from the King's Liege. We continue only with the work that King Edward the Peaceful began, honoring our patrilineal society. Lastly, all church members must participate in weekly check-ins. Officers must reach out to the King weekly, and failure to do so will indicate a lack of direction. Following will lead to reevaluation on your positions within the church. Thank you again for your time. If I do not hear back from you by Wednesday, I will take that as your response. Psalms 11:12 points out, Psalms 112, section 1. Praise the Lord, hallelujah. Blessed, fortunate, prosperous, and favored by God is the man who fears the Lord with awe-inspired reverence and worship him with obedience, who delights greatly in his commandments. Sincerely, Archbishop Dion de Belmont, the Third Temple English Church of England. Okay, and it has my seal. So I hope you all got that notice by way of email, and all those who are here tuning in tonight, you also got notice as well. All right, so it's very important to understand what it is that we do here at the English Third Temple Church of England. And with that, let's get started with this marvelous lecture. The lecture is called Secular Liberalism is a breach of the King's peace. Secular liberalism is a breach of the King's peace. All right, so we must pay close attention to this lesson because it's one of a kind. It's one of a kind. Greetings to you, Brother Harib. Baby, we have a brother from I assume he must be a Moor here joining us today, so we welcome you. Hopefully what's being talked about today will give you some enlightenment about our society, the Third Temple English Church of England. So without further ado, please take notes. And also, if you have any questions pertaining to what's being talked about today, please ask them in the chat and I'll be able to get to them. Anything in regard to anything outside of that, I will not entertain. Okay, so let's get started. It's really all about your identity. Okay, this is what it's really about. Our identity here as one of the people, as part of the people, okay, supporting the people, because the sovereignty has been placed in the people, okay? When we're talking about the term United States of America, the sovereignty of America, known as the United States, is reserved for the people. Okay? You must understand that. And when you talk about the United States, you must go back to the founding of the United States. And the territorial where the founding of the United States resided. Very, very important. So please pay close attention as I try to explain this and simplify it for those who claim to be scholars. All right? Please pay close attention. Greetings, Brother Thomas, from the House of Thomas. As you can see here on the screen, there's a depiction that shows a description about the relationship of politics and religion. And the politics and religion being amalgamated is a recipe for disaster. Okay? Politics and religion is a recipe for disaster because a polity and politics is different. Okay? I didn't say polity. I said politics and religion mixed is a recipe for disaster. How is it disaster, King Clifford Jefferson? I'm going to show you. It's actually our fault, to be honest. It's actually our fault. Okay? It's our fault. Now I want to show you the status that all of you are in. When I speak about you, I'm talking about my people. All right? Of my ethnicity. I'm talking to you directly. Everybody else has to make a choice. You made a choice unconscionable, so that means that the choice that you made was unconscionable, which makes that choice unreasonable. Okay? Because you had little say of the matter. Okay? You had little say of the matter. Greetings, Countess Cersei from the House of Cersei. Glad you were able to join us today. Remember, all your free and common soakage gifts are welcome. You can send your donations to the Third Tip English Church of England, as well as to $ Clifford Jefferson L. And we'll be glad to make sure that you are listed amongst those who have paid their homage to the king in their respect, in that respect. Greetings, Brother McGarrell from the House of McGarrell. Glad you were able to join us today. So as you can see, it's the particular instrument that the majority of you have as proof of identification that's in your pocket right now. Everybody pull it out of your pocket, okay? Everybody pull it out of your pocket. If you ain't got it, that means that you don't have an ID in your pocket because majority of the IDs now require this description. And it states, this instrument, known as the new auto driver's license in New Jersey. I'm pretty sure it was adopted in other states as well. But it says, and I paraphrase, not paraphrase, and I quote, not for real ID purposes. Do everyone see that? Not for real ID purposes. So this instrument that is created by the state and gave it to you through an agency of the state, all right? And within it, it was in the contractual agreement that you willingly and unconsciously agreed to. And as they stated on the top of the instrument now, that it does not serve the purposes for actually identifying you, okay? Or the real purpose for the instrument. The purpose and intent for the instrument is for the granted privilege of driving or traveling by whatever means you do that traveling or driving, crawling, whatever. They got an instrument that says that this particular instrument is not for real ID purposes. Okay, you really need to take a look at that. Okay, you really need to seriously take a look at that. Pull it out your pocket. So what you saying, King? Let's show you what's wrong with that picture. Back in 2005, the legislative act was passed, which was called the Real ID Act. Okay? It was called the Real ID Act. Okay? So it had nothing to do with driving at all. Nothing to do with driving. Greeting Archbishop Belmont from the House of Belmont. Glad you could be here to moderate. So the Real ID Act of 2005, which on the face of the instrument says that it's not for real ID purposes. So if this instrument is not for real ID purposes, so it's already predetermined when they pull you over or when they ask for it, how they're going to identify you. Does that make sense to anybody? Whether you got a driver license in your pocket or you got an identification card from motor vehicles in your pocket, is already predetermined how they're going to determine who you are, and it's not based upon identifying you with what? A real person, because real people have what? Real IDs, real identification. So what determines what is a real identification for natural person and a legal fiction? Okay? What is an instrument that determines who a real person is? Because this ID is not for the purposes of real ID. Determine if you are a real person. Let's go back to the instrument. Look at it again. Look at it again. Front cell. All right, there you go. There you go again. All this result originated from the Real ID Act in 2005. So this is how long this act has been in play. This is the Real ID Act of 2005, styled a Real ID Act of 2005, is an act of Congress that established requirements that driver license and identification cards issued by the United States and territories must satisfy to be accepted for accessing federal government facilities, nuclear power plants, and for boarding airline flights in the United States. That's a throw off. Don't believe that. Okay? It's not for that purpose. Okay? It's to relieve them of their obligation to you based upon their right to protect its citizen. Because that instrument identify you based upon the face of it says that it does not have anything in lieu of real identification. Okay? Because this applies to driver license and identification cards. So if you got an identification card on you and it says not a real ID, then guess what? You're in a world of trouble. Okay? All this goes back to the 9/11 attack. Okay? September 11 attack. So we must understand what's at play. Let's read a little bit more. The requirement includes verification of the personal information presented when applying for identification documents, security features on the document and electronic sharing database between states. The Act also made various modifications to the United States immigration law regarding asylum, border security, deportation, and specific work visas. Y'all better listen to me. Okay? Y'all better listen to me. Us as English ancestor successors, we don't have a problem. What you mean we don't have a problem? Let me show you. This is what we give our citizens, our subjects, our loyal subjects who are loyal and took their oath to not only be heirs of the crown, but to protect the crown. This is the ID cards that we present that denotes to us as real people. Okay? This is what we give to our members. All right? And here's an example from me, your king. Nationality card, identification card, a allodial substantive birthright. So you got a right to be here. You got your free name, your English name, your born date, your national domicile, i.e., in England, your ancestral estate in regards to your right to be here is from the Plantagenet crown. Okay? Co-address, all right, where you recently domicile, okay, and the territory of the province of New Jersey. Your nationality is an English national. Your signature, okay, you got an identification description of who you are, your height, your weight, your hair color, your eye color, with the royal seal, as well as the authority that denotes to their obligation to protect you. The Magna Carta 1215, as well as New Jersey Revised Statute 16:1-28, 430, as well as 6-2, as well as New Jersey Revised Statute 101, 201, 202, 301, and 302. These deals with the going to the laws of presumption, the laws of presumption. All right. So this is the identification card that we give you. All right. On the back of that, of this card, that we present to our members when you become a member. Royal standards of an English person. This is the royal standard. Let me blow it up for you. You can thank our bishop for this. In the first place, we have conceded to God, and by this our present charter, confirmed for us and our heirs forever that the English church should be free, and shall have her rights entire and her liberties inviolate. And we wish that it be thus observed. This is apparent from the fact that we of our pure unconstrained will did grant the freedom of elections, which is reckoning most important and very essential to the English church, and did by our charter confirm and did obtain the ratification of the same from our Lord Pope Innocent III, before the quarrel arose between us and our barons. This freedom we will observe, and our will is that it be observed in good faith by all our heirs forever. We have also granted to all freemen of our kingdom, for us and our heirs forever, all the unwritten liberties to be had and held by them and their heirs of us and our heirs forever. Exodus 20:12. Honor thy father and thy mother, that thy days may be long upon the land which the Lord thy God has given thee. All right? So this is our identification that we give our members here in what we call North America and the territory known as New Jersey, and we know that was known as New Jersey Provincial Council, or ran by the New Jersey Provincial Council, which was represented by the Crown, which I represent in this present day. Okay? So you either can take this instrument and be identified by, based upon the contractual agreement that you make, which is nothing more than the oath of allegiance. Okay? Or you can use this instrument. You can use theirs. And it says not for real ID purposes. Okay? Not for real ID purposes. All right? We got the authority to do it. We have the authority to do it. How many of your leaders can show you that they got the authority to do what it is that we're doing? Okay? This is filed in the county. The county records shires. Okay? The shires were under the authority of the sheriffs who managed the estate under the authority of the courts. All right. The king's courts, or what they're called the assize courts. All right. Created in 1166. How many of you know that? Okay. Right here in New Jersey, what you call New Jersey now. All right. We must comprehend that this power that we have is right and exact. Okay. The undersigned, each with the capacity to contract, hereby execute and acknowledge the certificate of a corporation for the purpose of the forming a religious nonprofit in accordance with Title 16, 1:1, 1:-2, as prescribed by the title pursuant to Georgia by Statute 16:1-28 and 16:1-4. 61-28 says right state under the charge of Great Britain, save from appeal, an act to incorporate trustees of religious society for property held in corporation place thereof. Okay? As you can see, there's our territory, the Kingdom of England. Everybody see that? Everybody see that? So we have the authority to do what it is that we do. I have the authority to do what it is that I do. Why? Because Article 2, according to our business type, says this is a corporation sole of a royal peculiar, the crown. A corporation sole is a legal entity consisting of a single sole incorporated office occupied by a single sole natural person. This structure, y'all hear me? This structure allows, all right, corporations, often religious corporations, or Commonwealth government, i.e., the House of Stuart. It was a Commonwealth, what you call the Republic now, all right? So it's either a religious corporation or Commonwealth to pass without interruption from one office holder to the next. Given positions legal continuity with subsequent office holders having identical powers and possession to their predecessors. Okay? Identical to the powers of the recent or the past one who was sitting in that position or station. Okay? We must comprehend what's going on. Article 3. What is the intent or the purpose of our society? It is a means for orderly transfer of ecclesiastical property, serving to keep the title within the denomination of our religious society, in order to keep the religious property from being treated as an estate of the vicar of the Roman Catholic Church. The property was titled to the office of the corporation sole, and the corporation sole, the crown, is the legal embodiment of the executive, legislative, judicial governments, and the monarchy of each commonwealth rim. Okay? All this is filed for the record. These monarchies are united by a personal union of their monarch, but they are independent states. The concept of the crown developed first in England as the separation of the literal crown and property of the kingdom from the person or personal property of the monarch. Okay? And also Article 4. Magna Carta Clause 4, Clause 1, the same thing you read on the back of your card. Those who are members, subjects of the crown, all right? The liberties of the English church first that we have granted to God and by this present charter have confirmed for us and our heirs in perpetuity that the English church shall be free and shall have its rights undiminished and its liberties unimpaired. As the English king heirs his successor's duty and allegiance to restore the period's life and history of the English Anglo-Saxon Berbers. English church, our customs, our laws, traditions, our religious beliefs back to time immemorial here in America, commemorate our saints, martyrs of the past kings and queens, restore the mysteries of our Jesus Christ, also known as King Edgar the Peaceful, which I am the reincarnation of in this present day. Okay? So there you go. We have the actual authority to do what it is that we're doing. Okay? We ain't talking about it. We are about it. Let's look at our powers before I close out on this. Everything is prescribed by the statute. Powers. Powers every religious society or congressional incorporated by virtue of any law of the state shall have the power to one, A, have perpetual succession of such corporation, B, sue and be sued, plead and implead in any court, C, adopt and use a common seal, and alter and renew the same at pleasure, D, appoint such officers, agents, and employees as may be required for its properties, institutions, and businesses. E, make bylaws and rules consistent with the laws for the regulation and management of its affairs, properties, and institutions. F, acquire, purchase, receive, have, hold, take by devise, bequeath, or give without limit real and personal property of all kinds. Church edifices, schoolhouses, college buildings, parsonage, sister houses, hospitals, orphan asylums, and all other kind of religious, ecclesiastical, educational land, charitable institutions, and the lands whereupon the same are or may be erected, and cemeteries or burial places, and any real estate suitable for and any of all of said purposes. G. Lease, grant, sell, and dispose of all or any part of such property. H. Borrow money for the purpose of the corporation and to give bonds and mortgages therefore on any part of its property. I. Have the management, direction, and control of all the civil and temporal affairs of the congregation, church, or parish, and J, exercise any corporate power necessary and proper for the carrying out of the above enumerated powers and the purpose of the corporation and its institution. Do you see what we are talking about? Why? Because we are, in fact, a government. How we know it? Let's read it before I move on. New Jersey by Statute 16:1-43.9. Read it in whole. Powers of consolidated corporations, the consolidation of corporations shall have and may exercise. You hear that? Shall have and may exercise all powers conferred by the respective certificate of incorporation or charter, one and the same, of the constituent corporation under Title 14 or under Title 16. When you deal with under Title 14, it's under commerce. When you do it under Title 16, it's for religious purposes. Okay? We must make the distinction. So if you do it under Title 16, under Corporation, Association, Religion, it says that the powers conferred by Article 5 of Chapter 1 of Title 16 of the revised statute, so far as the same are not inconsistent with this act, are necessary or convenient to the furtherance of its objects and are in accordance with the doctrine, government, discipline, and uses of the church or the religious denomination to the jurisdiction of which the constituent corporation were subject. Did you hear that? So we are, in fact, a government. Okay? We are a government. So with that being said, let's move on with this lesson. Constitution. We're going to show you how they breached the king's peace. Okay, I'm going to show you how they breach the king's peace. The Constitution of the State of New Jersey is the basic governing document of the state of New Jersey. You hear that? In addition to the 3 British royal charters issued for East Jersey and West Jersey. When New Jersey was ruled under the Crown, it was under the Crown was an itinerant court was set in either Perth Amboy, where we at now, or Burlington. Okay, Burlington was West Jersey, Perth Amboy is East Jersey. Okay, where we now reside. Okay, so it says the Constitution of the State of New Jersey is the basic governing document of the State of New Jersey, in addition to the 3 British royal charters issued for East Jersey and West Jersey, and united New Jersey while there were still colonies. The state has been governed by 3 constitutions, i.e., 3 birth certificates. The first was adopted on July 2nd, 1776, shortly before New Jersey ratified the United States Declaration of Independence. So when you talk about the United States, their constitution, when they were separate colonies, the paramount document or the paramount constitution or the paramount charter was this one you're talking about right now, July 2nd, 1776. And it says shortly before New Jersey ratified the United States Declaration of Independence, and the second came into effect in 1844. The current document was then adopted in 1947 and has been amended several times. So they're all talking about New Jersey's Constitution, and New Jersey's Constitution of 1844 was similar to the United States Constitution of 1789. Okay? It was presented September 10th, 1947, okay, and ratified November 4th, 1947. Okay? We must understand this. All right. So the first birth certificate of New Jersey, very important. The United States wasn't even a thought, okay? Wasn't even a thought. So it says the three fundamental documents has governed the territory now known as New Jersey. The first was the concession agreement, which was written in 1665 by the colony property Lord John Berkeley and Sir George Carteret, and included a provision granting religious freedom. So the religious freedom that was done by what you call the United States was preceded by the religious freedom going all the way back to the proprietors, Lord John Berkeley and George Carteret. After Berkeley and Carteret sold New Jersey to the Quakers, the colony was split into East and West Jersey. Each had its own charter, i.e. constitution. Then the West Jersey Constitution of 1681 and the East Jersey Constitution of 1683, and then the two were then reunited under the what we call the Provisional Council in 1702 under the authority of, or the monarch of what we call Queen Anne. Okay? They were united in 1702. It was called the Crown. All right? It was called the Crown. And the Crown was ruling prior to this. Okay? Because the Crown authority is what? Indefinite. Okay? The Crown was operating back in the time of our ancestors. All right? Even though it was being overseen or being ran by de facto rulers. Okay? We must comprehend the legacy. New Jersey's first state constitution was adopted on July 2nd, 1776. The American Revolutionary War was underway, and George Washington had recently been defeated in New York, putting New Jersey in an imminent danger of invasion. Okay? Watch the terms they use. With patriots and Tories faction plotting and battling each other, New Jersey was in a state of war and was nearly at a state of civil war. Composed in a span of 5 days and ratified only 2 days later, during the state of emergency on July 2nd, 1776, the New Jersey State Constitution reflects the turbulence and uncertainty of the moment. Its primary objective at that time was to provide a basic temporary governmental framework that would preempt New Jersey from falling into, everybody say the word, anarchy. Yet the Constitution served as the charter document for the state government for the next 68 years to prevent the state from going into a civil war. Anarchy. Keep that thought in mind. Civil war or anarchy. This was nothing more than an adopted event that had preceded this presumed anarchy or civil war. This is why they created that charter. Okay? That charter overtook your estate when the estate of those who owned the estate were warned against themselves. Okay? We must comprehend that. And that estate actually belongs to who? The Plantagenet crown. That's who you think is coming to retrieve it. And Plantagenet king. All right? This is going to make very good sense when you finish this lesson. Let's move forward. Let's go to the succeeding Constitution, which is the 1844 Constitution. It says the succeeding Constitution, adopted on June 29, 1844, restricted suffrage to white males. It separated the governmental powers into judicial, legislative, and executive branches, and granted the people, as opposed to the legislator, the ability to elect a governor. It also formally limited state debt, a predecessor of many contemporary debt ceiling clauses. The Constitution was amended in 1875, mainly to conform to the 14th and 15th Amendment once they freed us from slavery. Then they made us citizens. All right? We must understand what's at play now. So they didn't think about us in regard to the constitutions that preceded the 1804 Constitution. Okay? They didn't even have us in mind. All right. Why? Because we was the property. So when they created their constitution was to separate the property, i.e., the land, and the people who lived on the land, which was considered private property. Okay. So if you're a private property on the land and they had the land, i.e., the property, guess what? Then all land is ceased to the state because it's interstate. Ain't no more heirs. Okay. Now it become abandoned, what they call bona vacantinia, abandoned property. We must comprehend what's going on. Greetings, Brother Cornier from the House of Cornier. Glad you could join us. Now we got the 1947 Constitution. Very important. All right? All talking about New Jersey. New Jersey's Constitution, 1947. Let's go to Article 10, Paragraph 4. Very important. General provisions of the 1947 Constitution of New Jersey. It says Article 10 contained involves miscellaneous final addenda. Okay? Everybody pay close attention. Paragraph 1 states that the seal of the state shall be kept by the governor or person administering the office of the governor and used by him officially and should be called the Great Seal of the state of New Jersey. The seal design and the state flag are not mentioned. Paragraph 2 provides for the salutation and protocol of giving grants and commissions. Okay? Paragraph 3 states that all writs shall be in the name of the state. All indictments shall conclude against the peace of the state, the government, and dignity of the same. And paragraph 4 provides for a rule of construction of the word such as persons, and all pronouns include both sexes. Okay? But what we need to focus on in paragraph 4, all that's being done for the justified by their constitution is based upon paragraph 3. Because when you disturb the peace, all right, when you violate the law, all right, or disorderly conduct, you have breached the peace of the state. Okay? You have breached the peace of the state. So paragraph 3 states all writs shall be in the name of the state, all indictments shall conclude against the peace of the state and the government and dignity of the same. Very important that we comprehend that. Why is this important? Let's just go ahead. New Jersey Prevention Council. Majority of you seen this before. We've been through it many times. His Majesty's Council for the Province of New Jersey was the upper house of New Jersey legislature under colonial rule until it was replaced by New Jersey Legislative Council under New Jersey's Constitution of 1776. This was declared after they declared their independence during the time of the Revolutionary War. This was a breach of the king's peace. Remember that. This was a breach of the king's peace. Why is it? Because the Provincial Council was established in 1702 upon the surrender by the properties of East Jersey and those of West Jersey, known as John Berkeley and George Carteret, of the right of government to Queen Anne. Anne's government united the two colonies as the province of New Jersey. A royal colony established a new system of government. That government was ran under the authority called what? the crown. All right? The term of the crown was indefinite, forever. Okay? It was forever. Okay? We must comprehend that. East Jersey is Perth Amboy and West Jersey is Burlington. Okay? Very important stuff you must understand. Instruction from Queen Anne to Viscount Cornbury, the first world governor, before any other governor that you got today, the first world governor under the authority of the crown, under the under the authority of the monarch who represents the crown and protects crown land, which is the intel estate. It says that the instructions from Queen Anne to Viscount Cornbury, the first world governor of New Jersey, he outlined a fusion of power system which allowed for an overlap of the executive, legislative, and judicial authority. It provided for a bicameral legislative consisting of a council and general assembly. Okay? We must comprehend that. On December 6, 1775, Governor William Franklin paroled the New Jersey legislature until January 3rd, 1776, but it never met again. On May 30th, 1776, Franklin attempted to convene the legislature, but was met instead with orders from New Jersey Provincial Congress for his arrest. On July 2nd, 1776, the Provincial Congress approved a new constitution, and on August 13th, the New Jersey legislature was elected, with the appointed Provincial Council being succeeded by the elected New Jersey Legislative Council. This was a breach in the King's peace. It was a violation of Article 10, Paragraph 4 of the 1947 Constitution, because 1844 Constitution was violated, as well as the 1776 Constitution was in violation. Why? Because you did not go based upon the common law of England. That was the municipal law of New Jersey, the common law of England. We must comprehend that. So as a result of you violating the common law but not following the common law, it was a breach of the King's peace. Okay? It was a breach of the King's peace. Let's go here. And my mama's name was Betty Ann. Betty Ann Jefferson. Okay? Betty Ann. There was also the Powhatan Queen, name was Queen Betty or Queen Anne. All right? The Powhatan Queen, her name is Queen Betty or Queen Anne, and my mother's name was Betty Ann Jefferson. That's the name on my birth certificate. All right? So here we have New Jersey website. And first, we're going to look at two constitutions: the 1776 Constitution, which was the contract that they were not supposed to break. Why? Because it maintained the King's peace. Okay? Or the law of peace. Okay? It maintained the King's peace, or the law of peace, or peace law. Okay? Native Americans had their term for it. It was called the Great Law of Peace. All right? So in the 1776 Constitution, based upon the original contract made by the contracting party, which was nothing more than a temporary charter. Our charter, when we incorporated as the Crown, was not a temporary charter. All right? Our charter was indefinite, as it was when it was originated with Queen Anne, as it was originated prior to Queen Anne, as it originated going back to time immemorial. Okay? So on July 2nd, 1776, New Jersey became the fourth American colony to adopt a charter or a constitution declaring independence from Great Britain. That was a breach of the King's peace. It was composed in 5 days, and although the delegates considered it a temporary charter, it remained New Jersey state constitution for 68 years. Okay? So Wikipedia validated what we're reading here on New Jersey website. Okay? Now let's go to Article 22 of the original Constitution that they took an oath to under Article 23. Okay? In Article 20, they separated the powers of the king's government, which was a fusion of government under the crown. Who did it? The Protestants. Okay? Under what? Secular liberalism. Okay? Secular liberalism. Article 28, Article 29, Article 20, part so. Article 19, what's that? Article 18, Article 19, Article 20, and Article 21, we see that the freedom of worship was based upon liberalism, secular liberalism. For who? The right of the Protestants, all right? Then they separated, as a result of their rebellion, they separated the king's government, all right? They separated the king's government. You're absolutely right. Anglo-Saxon white Protestants, okay? Article 21, they continue the provisional laws, all right? And because they adopted some of the law that was already there in their charter, i.e., their constitution. And what law was that? That was the continuation of the law of that municipal law, which was called the municipal law of the Kingdom of England. Okay? Yes, the law of New Jersey for the municipality of New Jersey was the law of the nation. It was called the common law of England. And they both took an oath of affirmation. They all took an oath of affirmation to protect that common law of England. And they also put in place a nullification provision and certified that nullification provision that if there was ever a reconciliation with the crown, that this charter we're talking about, as well as the 1844 and 1947 Constitution, and that includes all the constitutions created for all the other states who joined the compact, become null and void. Null and void, okay? So let's see Article 22. Article 22 states that the common law of England, as well as so much of the statute law, has been herefore practiced in this colony shall remain in force until it shall be altered by the future law of the legislator. Such parts only, it didn't say abolish, it say alter, but not abolish, by a future law of the legislator, such parts only except as are repugnant to the rights and privileges contained in this charter, and that the estimable right of trial by jury, remember, trial by jury, write that down, should remain confirmed as part of the law of the colony without repeal forever. So who created the trial by jury? Who created the courts to have trial by jury? Okay? Who created all that? 23. The only one who created that must be the ones who created the common law, because the courts worked off the common law. Okay? We're going to prove it. 23, that every person who should be elected under that common law of England, okay, who have been elected under that common law of England, who should be afforded for himself. They say everyone who be a person who should be elected as aforesaid to be a member of the Legislative Council or House of Assembly should previous to his taking his seat in the Council of Assembly take the following oath of affirmation. You hear that? That they solemnly declare that as a member of the Legislative Council or Assembly, as the case may be, of the colony of New Jersey, I will not assent to any law, vote. Think about now, we're talking about modern day now. They made an oath way back then, based upon their obligation back then, based upon their oath of allegiance back then, right? Based upon an oath of allegiance back then, according to the common law of England back then. All right, not according to their common law, but to the common law of England, based upon chapter or section 22 and section 23, which we're reading right here in from the actual sections. It says that I will not assent to any law, vote, proceeding which will appear to be injurious to the public welfare. That means you of said colony, nor that shall annul or repeal that part of the third section in the charter of this colony, which establishes that the elections of the members of the Legislative Council and Assembly should be annual, nor that part of the 22nd section in said charter respecting the trial by jury. Once again, who created the trial by jury? Who created the courts to have a trial by jury in? We must answer that question. Nor that shall annul or repeal or alter any part or parts of the 18th or 19th section of that same, and any person or person who shall be elected as aforesaid is hereby empowered to administer to the said members of the said oath of affirmation. Okay? So if you violated what we just read, then that is a breach of what, y'all? The king's peace. Provided always in its true intent and meaning of this conquest, that if a reconciliation between Great Britain and these colonies should take place, and that the latter, i.e., those colonies, be again taken under the protection and government of the Crown of Great Britain, this charter should be null and void, otherwise remain firm and inviolable. You hear right there. Okay. So if this is in the 1776 Constitution, where it says that they are obligated to, one, enforce the common law, two, take an oath of allegiance to that common law of England, three, that if there was ever a reconciliation with Great Britain, that that charter that they go by, which gives them all the authority they do what they're doing, will then now and forever be considered null and void. Okay? Right there. So as a result of that, that means that when I came back, they were supposed to return the crown and crown property. If you didn't, that was a breach of the king's peace. Keep writing these things down. I'm not saying them just to be saying them. Okay, let's move forward. So what does breach of the peace mean? What does it mean? Because it says in, let's see, this says in Article 10, paragraph 4. Okay? Article 10, paragraph 4. Let's go to the Constitution of Jersey, Wikipedia. All right? Paragraph 3 states that all writs shall be in the name of the state. All indictments shall conclude against the peace of the state, the government and dignity of the same. Okay? What is the peace of a state? The legal term peace, sometimes king's peace or queen's peace. Okay? You hear that? You see it? It's the common law concept of the maintenance of the public order. Okay? It's the maintenance of the public order. So let's look a little bit more into that. Breach of the king, breach of the peace. All right? Let's look a little bit more into that. Breach of the peace, as established in Article 10, paragraph 4. Breach of the peace or disturbing the peace, okay? Disorderly conduct, assault, hurting somebody, injuring somebody, defaming somebody. All these things are a breach of the peace or disturbing the peace or disturbing the public order, which results in what we call disorderly conduct. Okay? So 99% of the citizens here in North America have breached the peace. Okay? That's including my people as well. If you don't know who I am, then you have breached the king's peace. Let's prove it. Let's go a little further into it. Public order. In England and Wales, theoretically, all criminal offenses, you hear that? Criminal offenses, cognizable by English law, involve a breach of the king's peace. And all indictments formed concluded against the peace of our Lord, you hear that? The king. His crown and dignity before the passage of the Indictment Act of 915 and the rules that formed that act first schedule. The conclusion has also found its way into constitutional law and many United States constitutions, which mandate that indictments within the state and in similar manner to the above usually omitting the crown part or substituting government. Did you hear that, y'all? Yes, brother. Wow. Did you hear that? The conclusion, and I didn't put that in there. What's the source? New Jersey State Constitution. We just read it. We just read it. When you click that, we go to where we just read. All right. So they have breached the king's peace. Only one can know it is the king. All right. And I'm showing you because it's right here in front of you. The conclusion has also found its way into constitutional law in many United States constitutions, which mandates that the indictment within the state end in a similar manner to the above, usually omitting. All right, usually omitting the crown part of or substituting government. For example, New Jersey is against the peace of the state, the government and dignity of the same. Did you hear that? So they're telling you when you hear the dignity of the same of the state of New Jersey, they're talking about the king's peace. Okay, why? Because they are a product of the king's government. It's indefinite. The crown is indefinite. They said they omitted it. They took it out. Just because they took it out don't mean it ain't there. Okay, you just don't see it. We must comprehend what's going on. Historically, that concluding phrase, now legally superfluous, represents the last trace of the process by which the royal courts assumed jurisdiction over all offenses, and gradually eroded the jurisdiction of the sheriff or reeve, and of lords or manors enfranchised, making crimes a matter of national concern as distinguished from civil wrongs or infraction of the right of local magnates. The peace of the king was sworn on his ascension or full recognition, and the jurisdiction of his courts to punish all violations of that peace was gradually asserted. The completion of this process is marked by the institution in the office of who, y'all? The Justice of the Peace. The Justice of the Peace. Y'all better listen to what it is that I'm telling you today. So, what is the justice of the peace? And who created the justice of the peace? Before we do that, let's go and define peace or peace law. Let's define that before we go to justice of the peace. The legal term peace, sometimes king peace or queen's peace, is the common law concept of the maintenance of the public order. The concept of the king's peace originated in Anglo-Saxon law, where it initially applied to the special protection accorded to the household of the English kings and their retainers. You hear that? You hear that? A breach of the king's peace, which could be either a crime or a tort, was a serious matter. The concept of the king's peace expanded in the 10th and 11th century to accord the king protection to particular times, such as holidays, places such as highways and churches, and individuals such as the gates. By the time of the Norman conquest, the notion of the king's peace became more general, referring to the safeguarding of public order more broadly. In subsequent centuries, their responsibilities for enforcing the king's peace, besides the king himself, you hear that? So if ain't nobody else doing it, I got to do it myself. Includes the king's bench and various local offices, including the sheriff, coroner, justice of the peace, and the constables. Did you hear that? And the constables. All right. So all these people are responsible for maintaining the peace, okay, in the rim. The king as well. But wasn't no king, so everybody else was obligated to do it because they are what you call the conservators of the peace. Everybody write that word down. The conservators of the peace. So what is the justice of the peace? Let's go to it real quick before we move on with this lesson. King never dies. All right. A justice of the peace is a judicial officer of a lower court elected or appointed by means of commission, i.e., a letter patent to what? Keep the peace. All right. A justice of the peace was appointed or elected by means of what? A letter patent to do what? Keep the peace. In past history, the term commissioner of the peace was often used with the same meaning. Depending on the jurisdiction, some justices dispense summary justice or merely deal with local administrative applications and common law jurisdictions. Justices of the peace are appointed or elected from the citizens of the jurisdiction in which they serve and are or were usually not required to have any formal legal education in order to qualify for such offices. All right? So where does this concept justice of the peace originated from? Because if you understand where the origin of the office of justice of the peace originated, then you know who to go to protect the peace on the land, especially when you're a subject. Because if the king can't protect you and his protectors, i.e., the ones prescribed to keep the king's peace, then guess what? You're living in hell. Okay? So the history of the origin of those who protect the king's peace, i.e., the justice of the peace, originated going back into what we call time immemorial. Time immemorial goes back to the time of Richard I. Richard I is the son of Henry II. All right, the son of Godfrey the Fifth Count of Anjou, the son of Folk, the ruler of Jerusalem, where my family line descend down from. So I am of noble blood. In 1195, Richard I, the Lionheart of England, and his ministers Hubert Walter commissioned certain knights to preserve the peace in unruly areas. They were responsible to the king in ensuring that the law was upheld, preserving the king's peace. Therefore, they were known as keepers of the peace. Did you hear that? It's about to get really good now, y'all. An act of 1327 had referred to good and lawful men to be appointed in every county in the land to guard the peace. Such individuals were first referred to as conservatives of the peace or wardens of the peace. This title, Justice of the Peace, i.e., wardens of the peace, i.e., conservatives of the peace, derives from 1361 and the reign of Edward III, son of Edward II, son of Edward I, son of Henry III, son of John, son of Henry II, who's the son of Godfrey the Fifth Count of Anjou, the ruler of Jerusalem. So it says that this conservative of the peace position, known as the Justice of the Peace, was established in 1361 by King Edward III. The peace to be guarded is the sovereigns. The peace to be guarded is the sovereigns, the maintenance of which is the duty of the crown under the royal prerogative. I repeat, the title Justice of the Peace derived from 1361 and the reign of Edward III. The peace to be guarded is the sovereigns, the maintenance of which is the duty of the crown under the royal prerogative. You hear that? Under the royal prerogative. So they were called what? Everybody say it. Conservatives of the peace. You hear that? Conservatives of the peace. That's very important. Because if there is no conservatives of the peace, then there is no peace. Okay? We must comprehend these legal, lawful, applicable terms. All right? These applicable terms. That brings me to what? the Establishment Clause. In the United States law, the Establishment Clause of the First Amendment of the United States Constitution, together with the Free Exercise Clause, form the constitutional rights of freedom of religion. The Establishment Clause of the First Amendment of the United States Constitution, together with the amendment of the Free Exercise Clause, forms the constitutional right to freedom of religion. Everybody needs to understand that. The Establishment Clause acts as a double security prohibiting both control of the government by religion and political control of religion by the government. The Establishment Clause acts as a double security prohibiting both control of the government by religion and political control of religion by government. Why? Because if there's a mixture, what is said, if it's, what's the name of the title? Where was that at? Politics and religion don't mix because it's a recipe for disaster. It is a recipe for disaster. Okay? So the separation of church and state, all right, was the result of political and religious differences. Okay? Political and religious differences. The clause was based upon a number of precedents, including the Constitution of Clarendon, the Bill of Rights of 1689, and the first Constitution of Pennsylvania and New Jersey. Once again, the Establishment Clause was the basis for freedom of religion, and the precedents for the freedom of religion was the Constitution of Clarendon, and the Constitution of Clarendon goes back to the 12th century. The Bill of Rights goes back to the 17th century, and the Articles of Confederation and New Jersey's Constitution and Pennsylvania's Constitution goes back to the 18th century. Okay, so we must deal with the precedents of the Establishment Clause, which is the free exercise of religion, because the free exercise of religion was a breach of the king's peace. I repeat, the free exercise of religion was a breach of the king's peace. Why? Because it created secular liberalism. Okay? Secular liberalism. Historical background. The Constitution of Clarendon is a 12th century English law had prohibited criminal defendants using religious law at the time in the medieval England, canon law of the Catholic Church, to seek exemptions from criminal prosecution. So if you violated the law and the church, you were found guilty, you could be held liable in a criminal action. Okay? That's how our ancestors did. So there was no need for politics. We already had the laws instituted in the religion. Okay? Because we understand that political and religion, when they mix together, it creates what it said. I just read it. I just read it. It's a recipe for disaster. Okay? It is a recipe for disaster. So you got the Constitution of Clarendon of the 12th century, the Bill of Rights of 1689. We're going to read about these in the case law in a second, as well as the colonial Constitution of New Jersey and Pennsylvania. We ain't got time to go through them because we just went through New Jersey. We already see how New Jersey breached the king's peace. All right, because they breached the contract. All right, Pennsylvania did as well with William Penn. They breach the king's peace. All right, let's move forward. All right. So the establishment clause was the basis for what? Freedom of religion. Okay. Freedom of religion. Everybody needs to write that down because it's going to be important why you shouldn't have the freedom of religion or the choice of what religion you're going to practice. All right. I'm going to show you the freedom of religion. Let's look at that. After this lesson, you never look at it the same. Freedom of religion or religious liberty, also known as freedom of religion or belief, is a principle that supports the freedom of individuals or communities, in public or private, to manifest religion or belief in teachings, practices, worships, and observances. It also includes the right not to profess any religion or belief or not to practice a religion, often called freedom from religion. Did you hear that? This is a breach of the king's peace. All right? This is a breach of the king's peace because this is called secular liberalism. The concept of religious liberty includes, and some say requires, secular liberalism and includes authoritarian versions of secularism. All right? So let's break that down. Let's break that down. What is secular liberalism? Secular liberalism is a form of liberalism. We know liberal means liberation, all right, freedom. And we call them freedom of religion, okay? And where secularist principles and values and sometimes non religious ethics are especially emphasized. It supports the separation of religion and state. Moreover, secular liberals are usually advocates of liberal democracies and open society as models for organized, stable, and peaceful societies. All right? Individuals, persons, it don't matter, Brother Cornier. It does not matter. If you don't understand the difference between politics and religion, you got a problem. Because your religion should have the polity in it, not politics, but a polity. Polity means a governmental structure. All right? There's a difference. So the individuals don't matter. The persons don't matter, especially if they're not natural persons. All right? So it says that, moreover, secular liberals are usually advocates of liberal democracy and open society as a model for organizing stable and peaceful societies. Secular liberalism stands at the other end of the political spectrum from religious authoritism, as seen in theocratic states and in liberal democracy. It is often associated with the stances in favor of social equality and political freedom. Let's get a little bit more deeper into this, all right? Let's get a little bit more deeper into this. Let's look at the term secular religion, okay? Secular religion, because we know that political religion and there's a difference. And we know religion and politics is a difference. Okay, so if you talking about a secular religion, that means that there's something wrong with the religion because the secular religion is not religion associated with spiritualism. Okay, we must comprehend that. Secular religion is what you call a secular state. A secular religion is what you call a secular state, because a secular religion, known as a secular state, is a state that has freedom of religion. And in order to have freedom for religion, there must be a separation of church and state. There must be a separation of church and state in order to have freedom of religion. And freedom of religion is called secular religion for the secular state, known as what we call secular liberalism. And all that came by way of what they call the Establishment Clause, okay, which is the freedom from religion. And it's based upon certain presidents, and the presidents that precede all the presidents that they mentioned was the Clarendon Constitution. Okay? the Clarendon Constitution. Everybody hold that thought. That's fine. Description of secular liberalism. Being secularists, by definition, secular liberals tend to favor secular states over theocracy or states with state religion. Secular liberals advocate separation of church and state in the formal constitutional and legal sense. Secular liberals typically see religious ideas about society and religious arguments from authorities drawn from various sacred texts as having no special status, authority, or purchase in social, political, and ethical debates. It is common for secular liberals to advocate the teachings of religion as a historical and cultural phenomenon and to oppose religious indoctrination or lessons which promote religion as a fact in school. Okay, so let's define secular religion. Secular religion is a communal belief system that often rejects or neglects the metaphysical aspects of the supernatural commonly associated with traditional religion instead of placing typical religious qualities in earthly or material entities. I repeat, a secular religion is a communal belief system that often rejects or neglects the metaphysical aspects of the supernatural commonly associated with traditional religion, instead placing typical religious qualities in earthly or material entities. This is what we call a state religion. Okay? A state religion. Secular state. A secular state is an idea pertaining to secularity, whereby a state is or purports to be officially neutral in matters of religion, supporting neither religion nor irreligion. A secular state claims to treat all its citizens equally regardless of religion and claims to avoid preferential treatment for its citizens based on their religious belief, affiliation, or lack of either over those who are profiled with other profiles. Okay? So you must understand that secular states practice secular liberalism, which is nothing more than a secular religion. All right? Let's see. Let's go define secular religion again. So if you are of the secular church and practice secular religion, which is secular liberalism, which means religious freedom to practice and believe in whatever you want to believe in, there's a problem in that. Okay? There's a problem in that because we don't practice whatever it is we want to believe in. We practice what our forefathers practiced based upon that system or culture that was practiced and passed down through time immemorial. Okay? So a secular religion is a communal belief system that often rejects or neglects the medical, physical aspect of supernatural, commonly associated with traditional religion, instead placing typical religious qualities in earthly or material entities. Okay? We must comprehend what's going on. Okay? So if this is what they're telling you, and apparently if this is what you identify in regards to identify yourself, then you are the one practicing the secular religion. Okay? You are the one practicing the secular religion. If you pull this out of your pocket, if you pull this out of your pocket, then that means that you practice a circular religion. All right? You practice a circular religion because this particular instrument is not for real ID purposes. Okay? Not for real ID purposes. So if that's what you're using to identify yourself, then they already identified you without you even knowing how they identified you. Okay? So this reason members of our society have IDs to properly identify ourselves. Okay? To properly identify ourselves. We must comprehend that. We must comprehend that. Okay, let's move forward. Let's see. The reason why we're in this situation, or the reason why a majority of you are in this situation, is because you don't understand law. Don't understand law. You think you're exempt from the law. Nobody is exempt from the law. All right? All you depend upon state law, federal law, to protect your rights. These laws were created by foreigners, okay, to protect themselves. All right. The only law you can use to protect yourself is that was the law originated here before those who created the communities who are foreigners. Okay. These are the people who reside in what you call your municipalities. Okay. These are the ones who reside in your municipalities. These are your local people. Okay. Your local folks. So if the local folks are participating in a local community, that would mean it would be your municipalities, your townships, your boroughs, your villages, etc. They all exist within what we call your counties, okay? Which at that time there was no such thing as a state, okay? They were called shires, okay? They were in fact called shires. So what is municipal law? What is municipal law? Everybody give a thumbs up in the chat if you like what you're hearing. Municipal law is the national, domestic, or eternal law of a sovereign state. Did you hear that? Municipal law is the national, domestic, or international law of a sovereign state. It is defined in opposition to international law. You got national law and international law. International law deal with foreigners. United States is a foreign nation. The only laws that they will entertain or uphold are international laws. Okay? For international subjects, which you call foreigners, who become naturalized as citizens by being foreign subjects by foreign rulers. Okay? And set up their shop in what? The municipality, because all your governments are ran through what? The municipality. Okay? Not in the state, not in the county, but in your municipality, because that is the seat of your government. The only thing you need to decide if it is a government, because a government is a nation that has a nationality, that has a law that's common to all the people. And the municipality that we're talking about, according to the law in which we're talking about, based upon the Constitution, as we were talking about, all mention one law. And what law was that? The common law of England. The common law of England. Municipal law is the national, domestic, or internal law. You hear that? Eternal law. So that's why they separated church and state. Okay? That's why they separated church and state and believe in whatever it is they wanted to believe it, so they can institute the laws governing their new state, all right, based upon their new secular religion. Okay? Their new secular religion through secular liberalism. And secular liberalism is nothing more than what we call uh, freedom of religion. Okay? Freedom of religion. You're absolutely right. It's a law. It is a law. So municipal law is a national law, domestic or eternal law of a sovereign state. Okay, and is defined in opposition to international law. So if you are national from a country other than North America, then you don't have any eternal law here. Does that make sense? You don't have any eternal laws to protect you here. That's why they have embassies set up here to protect foreigners who are protected by international law here. Okay, just like America got embassies set up in other nations got embassies set up here to protect their subjects here. Okay, but you are here. But what law protects you here under a sovereign state here? Because no state is sovereign here. Okay, it's the people who are sovereign here. But what people that are sovereign here have a nationality? All right, it's very, very important, because if you don't understand that, then you're subject to anything they give you. This becomes an unreasonable contract or unconscionable contract. All right. Municipal law includes various branches such as criminal law, private law, administrative law, and constitutional law. It is enforced by domestic courts and administrative bodies. Municipal law is tailored to the unique needs, values, and circumstances of specific political entities it governs. You hear that? For instance, traffic regulations, criminal code, and property laws are examples of municipal law that vary from one country to another. This is very, very, very important. Why is this important? Because we need to go by the laws, or be protected by the laws based upon, right, the peace, the king's peace, right? The peace. If the peace is broken, then it's a breach of the peace. And what peace is that? It's the king's peace, right? It is the king's peace. And the one who upholds the king's peace is called what? The justice of the peace. Point so. So back to justice of the peace before we move forward. The history of that office or position or station In 1195, Richard I of time, who created the term time memorial of England, and his minister Hubert Walter, all right, commissioned certain knights to preserve the peace in unruly parts. So let me share. Yeah, I was good. In 1195, Richard I of England and his minister Hubert Walter commissioned certain knights to preserve the peace in unruly areas. They were responsible to the king in ensuring that the law was upheld and preserving the king's peace. Okay? Therefore, they were known as keepers of the peace. An act of 1327 had referred to good and lawful men to be appointed in every county in the land to guard this peace, i.e., the king's peace. Such individuals were first referred to as conservators of the peace or wardens of the peace. The title Justice of the Peace derived from 1361 in the reign of Edward III. The peace to be guarded is the sovereign's, the maintenance of which is the duty of the crown and royal prerogative. So if you are the Plantagenet crown, then you are obligated as the conservator of the peace. So if you are a member of the English Third Temple Church of England, you are a conservator of the peace. You are obligated to protect the king's peace. All right? The statutes require it. How we know that? Let's see. What is the conservator of the peace again? Let's just look at it in Wikipedia. Conservator of the peace in ancient British custom. So British custom recognized the position of those who were known as conservators of the peace or wardens of the peace, which were individuals who had a special charge by virtue of their office to see that the king's peace was kept. You hear that? The king's peace was kept. In the 18th century, legal writer Thomas Ediling Tomlins and the 1820s legal dictionary defines conservative of the peace as a person who, until the creation of the justice of the peace by King Edward III, had an especial charge to see the king's peace kept, either as instance to other office, or of itself. You hear that? So the justice of the peace appointed by King Edward III had an especial charge to see that the king's peace kept, either as instances to other offices or of itself. The king was the principal conservator of the peace within all his dominions. Other general conservators of the peace include Lord Chancellor, Lord Keeper, Lord Treasurer, Lord High Steward, Earl Marshal, Lord High Constable, Justice of the King's Bench, and Masters of the Rolls, and that the common law sheriffs and sometimes constables were regarded as conservators of the peace within their county, and constables of the tithingmen was also were regarded as conservators of the peace within their jurisdiction. So this word, conservators of the peace, was not a loose word. Everyone knew what that word meant and the obligation of what that word meant. And if you didn't live up to the obligation, then guess what, y'all? You breached or broke the king's peace. So that means you are not a conservator of the king's peace back then and in the present day. How we know that? Let's look at it today. Let's see. 2023 New Jersey Revised Statute, Title 2A, Administrative and Civil Criminal Justice. Conservatives of the peace, powers and duty. Same word, conservatives of the peace. Any judge of the Superior Court or of the municipal court shall have power to cause to be kept all laws made or to be made for the conservation of the peace and for the good government of the citizens and the inhabitants of the state within their respective counties according to the force, form, and effect of such law, and to apprehend and to cause to come before them and imprison and punish all persons offending against such laws, or any of them in their respective counties, any in such manner as according to such laws should be right and proper, and to perform and execute all such matters, acts, and things as by law appertain to their office, and are or should enjoin upon them, or be committed to the charge and execution. Did you hear that, y'all? To not live up to this statute is what? A breach of what? The king's peace. Because you are what? A conservator of the peace. And the statute of 2A colon 151-1 says any judge of the Superior Court or of the municipal court shall have the power to cause to be kept all laws made or to be made for the conservation of the king's peace and for the good government of the citizens, inhabitants of this state within their respective counties, according to the force, form, and effect of such law, and to apprehend or to cause to come before them and imprison and punish all persons offending against such law, or any of them in their respective counties, in such manner as, according to such law, should be right and proper, and to perform and execute all such matters, acts, and things as by law appertain to their office, and are or shall be enjoined upon them, or be committed to their charge and execution. Okay? So there you have it. Conservators of the peace, those who are obligated to keep the king's peace, you are obligated. To not do so will be a violation of not just civil, but of criminal law. Okay? I didn't come to change the law. I just came to fulfill the law. Can everyone who watched the chat give me a thumbs up for that revelation? Okay? Give me a thumbs up for that revelation. All right. Twenty 23, New Jersey by statute, Title 2C. When you see Title 2A, it's the same as Title 2C. Brother Tribe Ties, I don't understand your remark. You said I put that in my trust. What did you put in my trust? I don't understand what you mean by that. Why you explain that, I'll read what the statute says. 2023 New Jersey Revised Statute, Section 2C, colon 27-12. Crime of corruption of public resource grading. Okay? Crimes of corruption of public resources grading, meaning that if you found in public corruption, you have breached the king's peace, or you have breached the peace of the king, as required by the statute. Because 2A is the same as 2C. Okay? Title 2C and Title 2A are the same because 2A deals with civil and criminal administrative law, and 2C specifically deals with crimes. And this says crimes of corruption of public resources and grading. How we knew that, let's see first. How is this crime? If we go to Georgia Revised Statute, Title 46, colon 3-2. Okay? We understand they breached the common law of England. they breached their obligation to return the crown back to the king. So that is a breach of the king's peace. How I know it? New Jersey by statute qualifies it. Okay? 2023. Let's get a new version up here. I'm still waiting on your response, Tribe Ties. It says here, the tenures and honors and manors, lands and tenements or of hereditaments or of estates of inheritance at the common law, specifically at the common law, held either of the King of England or any other person or body politics or corporate at any time before July 4th, 1776, and declared by section thereof an act entitled an act concerning tenures past February 18th, 1795, shall be turned into free and common soakage. Okay? So there you have it. So the fact that the land has been turned into free and common soakage by way of the King of England as corporation sole, representing the body of politics through his certificate of incorporation or charter, the land has now returned to the actual owner. And as a result of you not protecting this land, you have breached the king's peace. Okay? How I know it? You're supposed to return it back to me under free and common soakage. That's a form of feudal relief for the king. All right? Instead of taxing the king and the heirs, now you are paying taxes to the king for the heirs. Okay? Very important you understand that. This is why we go to New Jersey by statute. All right, so 2C colon 27-12. Okay? Because when you see Title 2A, it's the same as Title 2C. Let's just prove that real quick. I'm still waiting on that response, brother Tribe Ties. Your remark was that I put that in my trust. What is that remark referring to? As you can see, New Jersey statute annotated currentness deals with all the statutes that originated under the Title 2A, administrative and criminal procedures, has now been amended to fall under Title 2C, New Jersey Code of Criminal Justice. You see it right there? 2A, now it's 2C. All right? I ain't got time to go through that, but there you go. All right, let's move forward. New Jersey Revised Statute 2C colon 27-12. Public resources. Crime of corruption of public resources. A person who commits the crime of corruption of public resources, if with respect to a public resource which is subject to an obligation to be used for a specific purpose or purposes, the person knowingly use or make disposition of that public resource or any portion thereof for an unauthorized purpose. You see why all these judges, all these mayors and stuff getting locked up, you're about to see a domino effect. One, if the public resource involved is subject to an obligation to be used to perform or facilitate the performance of a governmental function or public service, corruption of public resources constitute a crime of the first degree. If the amount of the value of the public of the public resource involved is 500,000 or more, if the offense constitutes a crime of the second degree. If the amount of the value involved is 75,000 or more, but is less than 500,000, and the offense constitutes a crime of the third degree. And if the amount of value involved is less than 75,000, less than 75,000. Two, if the public resource involved is not subject to an obligation to be used for the purpose to perform or facilitate the performance of a governmental function or public services, corruption of public resource constitutes a crime of the second degree. If the amount of the value of the public resource involved is 500,000 or more, the offense constitutes a crime in the third degree. If the amount of the value involved is 75,000 or more, but is less than 500,000, the offense constitutes a crime of the fourth degree if the amount of value involved is less than 75,000. B, except as otherwise provided by Section 97 of Public Law 1999, a person commits a crime if he makes a material representation that is false to a governmental agency, officer, or employee. I repeat. Except as otherwise provided in Section 97 Public Law 1999, a person commits a crime if he makes a material representation that is false to a government agency, officer, or employee. 1, with the purpose to retain a public resource, or 2, with the purpose to mislead or deceive any person as to the use or disposition of the public resource. This offense constitutes a crime of the second degree if the amount or value of the public resources involved is 500,000 or more. The offense constitutes a crime of the third degree if the amount of value involved is 75,000 or more. But it is less than 500,000, and the offense constitutes a crime of the fourth degree if the amount of the value involved is less than 75,000. C, for the purpose of this section, public resource means any funds or property provided by the government or a person acting on behalf of the government, which should include but is not limited to what? 1, money or the equivalent of money paid by the government directly or indirectly to or on behalf of a person or his employer. 2, transfer by the government of any transfer of the government of an asset of value for less than fair market price. 3, fees, costs, rents, insurance, or bond premiums, loans, interest rates, or other obligations that would normally be required in the execution of the contract that are paid, reduced, charged at less than fair market value, waived, or forgiven by the government. 4, money loaned by the government that is to be repaid on a contingent basis. 5, money loaned by an entity based upon or according with a guarantee provided by the government. 6, grants awarded by the government or entity acting on behalf of the government. And 7, credits that are applied by the government against repayment obligations to the government. For purposes of this section, a purpose is unauthorized if it is not the specified purpose or purpose for which a public resource is obligated to be used, and the government agency having supervision of or jurisdiction over the person or public resource has not given it approval for such use. Y'all better listen to what I'm telling you. D, each act of corruption of public resources should constitute an additional separate and distinct offense, except that the amounts of values of public resources used for the unauthorized purpose is separate acts of corruption of public resources may be aggregated for the purpose of establishing liability pursuant to this section. E, proof that a person made false statements, prepare a false report, or if the government agency having supervision of or jurisdiction over the person or public resource required a report to be prepared, failed to prepare a report concerning the conduct that is the subject of the prosecution, should give rise to an inference that the actor knew that the public resource was used for the unauthorized purpose. Y'all better listen to what I'm talking about. Give me a thumbs up if you like what you're hearing. F, nothing in this act shall preclude an indictment and conviction for any other offense defined by the laws of the state. G, nothing in this act shall preclude an assignment judge from dismissing a prosecution under this section if the assignment judge determines pursuant to New Jersey Revised Statute 2C2-7 that the conduct charged to be a de minimis infraction. Okay? We must comprehend. hand. This is all statutory law. Let's go to another statutory law. 2A35-1. Administration of civil and criminal justice again. Jurisdiction of real property possessory action. Jurisdiction of real property action, possession action. 2A35-1. Any person claiming the right of possession of real property in the possession of another or claiming title to such real property should be entitled to have his right determined in the action in what? A superior court. Section 2 of that same title and chapter. Damage and limitation. In any such action, the plaintiff should be entitled to recover from the defendant any and all incidental damages, including misnamed profit, and the full value of the use and occupation of the premises for the time not exceeding 6 years before the commencement of the action during which the defendant was in the possession thereof. What is Section 3 of title and chapter? Where permanent improvements have been made, I don't want to read that section. There's another section we're looking for. I think it's this one right here. All right. So there you have it in there. 2A colon 35-1. All right. Any person claiming the right to real possession of real property in the possession of another or claiming title to such real property should be entitled to have his right determined in the action in superior court. Now, why is this important? Why is this important? All right, because when you take somebody else's property, that's theft. Okay, that's what we call disorderly conduct. You can't be stealing from somebody. Okay, so this is the reason why the courts were created in the first place to deal with keeping the peace. All right, to deal with keeping the peace. All right, let's see what we have here. State versus Meyer. In closing, Supreme Court, New Jersey. State of New Jersey plaintiff responded to versus Albert Mayer, defendant appellate. This case made it all the way up to New Jersey Supreme Court, 1952 case. All right. 1953, pardon self. Decided 1953. Please like, subscribe, and pass to others who are not privileged to actually hear this information. Okay. This decision was delivered by Chief Justice Vanderbilt. Okay. I like that judge. All right. Now we know that the laws of the municipality is the laws of the nation. Okay. Once again, the laws of the municipality is the laws of the nation. Let's look at it again before I read that in closing. Municipal law is the national, domestic, or internal law of the sovereign state and is defined as the opposition to international law. It encompasses the laws enacted by a national, state, or local government and is concerned with the regulating the behavior of individuals, corporations, and entities within the country. Now, we have to realize that there's only four types of citizenship. The Settlement Act of 1701 with Queen Anne that allowed foreigners to come here. The Naturalization Act of 1790, which gave the colonists, the founding fathers, the right to be classified as citizens based upon the color of the skin, had nothing to do with the nationality. Then the 14th Amendment, which was incorporated in New Jersey 1844 Constitution, that allowed um, uh, black people to now become participant in the municipal government. And then you got the Immigration Act. Okay, so there's only four ways that you can acquire citizenship, and all those citizenship deals with the term national, which, when defined in the federal government, it means a naturalized citizen, which only associated with the oath of allegiance. So therefore, it's not a proper identification, nor does it properly denote to a status that is protected by some law of some government, i.e., that municipal law. Okay, because the municipal law is a law of a nation, internal law of a nation, and not the law dealing with some the affairs of a government dealing with international affairs or foreign affairs. Okay, we must comprehend that. Let's go back to State versus Meyer. The opinion of the court was delivered by Chief Judge Vanderbilt. A complaint was made in the municipal court of Hoboken against the defendant Meyer, charged that he did willfully commit an assault and battery upon Frances Gianni by spitting upon her face and body of St. Francis Gianni, all in violation of disorderly persons law, New Jersey by statute 2A 170 2A colon 170-26, which is a new section enacted December 5th, 1951, reading as follows. Any person who commits an assault or an assault and battery is a disorderly person. This is disorderly conduct. Okay. It also was amended to New Jersey by statute 2885-1, which provides assault and batteries, false imprisonments, affrays, riots, routs, unlawful assemblies, nuisance, cheats, deceits, and all other offenses of indictable nature at common law and not otherwise expressed provided by the statute are misdemeanors. Okay, you see that? So on the 2A 170, what was it? 2A 170-26 and 2A colon 5585-1. This all deals with assaults that were denote to disorderly persons or disorderly conduct, which was a fractionable offense. Okay, we must comprehend that. Now, why is this important? The defendant moved to dismiss the complaint on the grounds that the statutory requirement under 2A 170-6, 170-26 was unconstitutional and that it violated three paragraphs of the Bill of Rights. Okay, it said he moved for dismissal in the municipal court because the statutory law in regards to the violation that he was charged with violated his rights as a citizen. Now we know the IDs that we have right now don't denote to citizens because they said they're not real IDs. So according to them, you are a foreigner, all right, because you're not identified. Okay, so that means that the Bill of Rights that he used to protect his rights in regards to the statutory law that was created by way of an amendment, all right, as well as a couple more amendments, he's deemed them to be unconstitutional because they violated the Bill of Rights. He went past the Constitution of 1776, 1844, and 1947. He went all the way back to the Bill of Rights, okay, which stated that no person should be held to answer for a criminal offense unless on a presentment of an indictment and a grand jury. So they're talking about the courts that deal with rights to a trial by jury under either Article 6 and Article 7. Okay, we must comprehend that. So, what did the court use to make their decision or dissent in lieu of the question brought before the court, in lieu of if the statute was unconstitutional or if the constitutional or if the statute was valid in its applicability? Okay, let's see. Let's scroll down and close it. The summary jurisdiction of the justice of the peace at common law. Okay? The general problem confronting us is not limited to New Jersey. It is a universal problem in the administration of justice. In every jurisdiction, it is necessary to provide the machinery for the effective punishment in summary fashion of minor offenses and breaches of the peace that fall far short of being crimes which require more formal treatment. Y'all better listen. At common law, this was the province of the justice of the peace. And who created that position? Edward III. Okay? Edward III created that position, and that position is being held up by presidents in a 1953 case in New Jersey Supreme Court. All right? Everybody give me a thumbs up if you like what you just heard. The keeping of the king's peace was one of the chief responsibilities as well as one of the great prerogatives of the crown. And guess what, y'all? I represent the crown today. Prior to 1327, it was exercised by who? Judges, sheriffs, coroners, and constables. All right? You hear it. The office of the Justice of the Peace had its origins in that year and the establishment of the local conservatives of the peace. You hear it? There go that word again. Conservatives of the peace by virtue of Edward I, which enacted that in every country, you hear that? In every country, pardon self, enacted in every county, good men and lawful men, which shall be no maintainers of evil or barrators in the country, shall be assigned to what? Keep the peace. At first, their authority was purely ministerial, paralleling that of the local constables. Gradually, however, that was granted judicial power in according to Lombard's the 23rd, after the passage of Edward III's law or statute that he passed, they became known as justices. You hear that? They were given authority to hear and determine at the king's suit all manners of felonies and trespass done in the same county. All right? History of the criminal law of England. But it is clear that the primary duty was to keep the peace and that the powers gradually accorded them were merely in addition to their basic powers of conservators. All right? To hear and determine trespass included a wide variety of offenses. That the word trespass in a word very general extent in a large sense not only comprehends all inferior offenses which are properly and directly against the peace as assaults and batteries and such like, but also all others which are so only by construction, as all breaches of the law in general are said to be pleased to the crown. He goes on to say that all these arises out of and were directly connected with the justice duty to preserve the peace. All right? The justice to preserve the peace. Let's see. Right here. This action, i.e., trespass, which you call the action of assumption, in Edward I's reign was a quasi-criminal proceeding, i.e., though it was a proceeding begun at the suit of the injured individual. It was aimed at serious and forcible breaches of the peace and ended in the punishment of the defendant as well as compensation for the plaintiff. Okay? A trespass then in Edward I's reign is a tort insofar as it began by an action of the injured individual, but it is also of criminal nature. A man can be punished for his trespass by the court which tries the action. Okay? So in closing, let's show you how powerful we are in regards to what Edward I demanded. Because when they stole our land and didn't return it, that was in fact a breach of the peace. Let's read that in closing. Title 46. Estates entails abolished. Whenever any conveyance, will, or instrument in writing shall hereafter be made, whereby any grantee, devisee, or other person should become seized in law on equity of such estate in any real estate as under the statutes of the 13th of Edward the First, St. Edward, in New Jersey by statute called the Statutes of Entail, will have been held an estate in fee tail or any type of character. Such conveyance, will, or instrument shall vest in estate now in fee simple. Okay? They stole it through fee simple. They turned an entail estate to fee simple estate. And the statutory law, regards to that, fee fee simple recovery under common recovery was also abolished right here. Was abolished. So the process in which they stole it was abolished as well. Fines and common recoveries abolished. From after June 12, 1795, 90.7, from after June 12, 1799, no fine or common recovery that has been or shall be entered, may have or suffer in any court of record in the state, should operate or be construed to be a conveyance or assurance of real estate, or in any way bar issuing entail, or the reversioner or remandering of the lawful claims and entries, and any usage of customs to the contrary is in any wise notwithstanding. So there's our remedy right there. What they stole through the process of common recovery, the courts has demanded that that process no longer lawful and has been abolished, and that the court is not going to entertain somebody who does retrieve land under that process called common recovery, which is known as what we call fee simple. And the states and the United States only way of ownership here in North America is fee and simple. And being that nature, they are unreasonable contracts. They are an unreasonable contract. And what is an unreasonable contract? In closing, let's read. An unreasonable contract or unconscionable contract. An adhesible contract, also known as a contract of adhesion, is a contract where the parties are of such disproportionate bargaining power that the party of weaker bargaining power could not have negotiated for a variation in the term of the contract. These contracts are prepared by the party with greater bargaining power for the use in all similar business transactions and given to customers on a take it or leave it basis. Did y'all hear that? On a take it and leave it basis. What are some of these contractors? Adhesible contracts are relevant in all fields, but are especially important in insurance, leases, deeds, mortgages, automobile purchases, and other forms of consumer credit. Nonetheless, courts have a long history of striking terms from these contracts or voiding the contract entirely when they determine the term to be especially aggregates to standards of fair play. All right. So as a result of that, being that we just read that adhesible contracts such as insurance, leases, deeds, mortgages, and automobile purchases, and all other forms of consumer credits are adhesible contracts, that means that they are unconscionable. And if that is the case, in fact, then what was I going to go? You need to go to a court of law that are able to give you remedy. And the only court of law that's able to give you remedy is the courts of our ancestors. These are called the assize courts. the assize courts. Let's read it in closing. The assize or courts of assize were periodic courts held around England and Wales until 1972, when together with the Court of Session, they were abolished by the Courts Act of 1971 and replaced by a single permanent Crown Court. The assize exercised both civil and criminal jurisdiction. Assize heard most serious cases, most notably those subject to capital punishment or later life imprisonment. Other serious cases were dealt with by the Court of Session, i.e., local county courts held 4 times per year, while the more minor offenses were dealt with summarily by the Justice of the Peace and Petty Sessions, also known in what we call magistrate courts. Okay? They were known as assize courts. Once again, assize courts. The assize courts were established by the assize Clarendon Constitution, and we know the Clarendon Constitution was the precedent for the Establishment Clause, okay, for the freedom of religion, okay. So it says by the assize Clarendon of 1166, King Henry II established trial by jury by a grand side of 12 knights and the land disputes and itinerant justices to set up county courts. Itinerant court was a moving court. Before the Magna Carta was passed and enacted in 1215, writs of assize had to be tried at Westminster or await trial at septiminal circuits of justice in Erie. The Great Charter provided for land disputes to be tried by annual assizes at more convenient places. This work soon expanded, becoming 5 commissions in 1293, and statutes were enacted which formally defined by assize circuits. So assize courts was created by the Assize of Clarendon in 1166, based upon the Constitution of Clarendon in 1164. Let's read this real quick. The Constitution of Clarendon was a set of legislative procedures passed by who? King Henry II of England, son of Godfrey the Count of Anjou, the son of Fulk, the ruler of Jerusalem. The Constitution was composed of 16 articles and represent an attempt to restrict ecclesiastical privileges and curb the power of the Roman Catholic courts and to extent of the papal authority in England. And the anarchic conditions of Henry II's predecessor, Stephen, the church had extended its jurisdiction by taking advantage of the weakness of the royal authority. The Constitution was claimed to restore the laws that was observed prior to Henry I, the son of William the Conqueror, who invaded England when it was under the authority of who? The Anglo-Saxon Berbers. And this resulted from anarchic condition. What is the anarchic condition? Which is resulted from what we call the anarchy. What is the anarchy? The anarchy was the civil war in England in Normandy between 1138 and 1153, which resulted in a widespread breakdown in our civil government. All right, a wide breakdown in law and order. I.e., there was disorder. I.e., a breach in the king's peace. The conflict was a war of succession precipitated by accidental death of William Allen, the only legitimate son of William the Conqueror's son, William Allen, who died in what we call the White Ship. He drowned. So in the White Ship drowned in the disaster in 1120. He sought to be succeeded by his daughter known as Empress Matilda. Empress Matilda is the daughter of Margaret of Anjou, who's the daughter of Margaret of Scotland, and Margaret of Scotland was Margaret of Wessex, who was married to who? Malcolm III. And that goes back to what we talked about, Earl of Perth. Earl of Perth was the entities who were ruling Perth Amboy. At the time, it was under the authority of the British Crown, ruled by Queen Anne. Okay, so in closing, you all have a serious decision to make today, based upon your freedom to practice whatever it is you practice. That's going to bring you some type of freedom here on earth. Okay? You must you must understand that. And if your freedom of religion is secular, then God is not in the equation. Okay? God is not in the equation. So you must understand that you have a choice to make in regards to your status. All right? Your status. Is it going to be this status, an identification card, or a driver license that's given to people that, in the purpose and intent to be given to you, is not to properly identify you because it's not a real ID. Contrast to what we have here at the English Third Temple Church of England, which is a real ID. Okay? A real ID. Because when they pull you over, the first thing they're gonna ask for is what? Identification, please. All right. He's gonna ask you two things: either identification or license and registration. Okay. Identification or license and registration. First thing they ask you for license registration, the first thing they must do before they ask for license and registration is properly identify who you are. And they cannot do that with the driving license or the identification card because it just said on the card, not for real ID purposes. So you must pull something out your pocket that's going to properly identify you and that will be acceptable in that state where you reside. Okay? You must comprehend that because when they run these statutes, these are modern day statutes that are reserved for those who are heirs and successors. Okay? We must comprehend that. All right? We must comprehend that. All right? So with that being said, let me make sure I covered everything. Yes, I did. So that being said, you really need to think seriously about what you're going to do in this time. Because I always say, time number one, when man was not, the life of time began, the time will come where you would be no more. And based upon that ID, who you thought you was is no more because it does not identify who you are as a real person because it says it has nothing to, or associated with a real identification of a real person. So the only thing it can be identified with is a legal fiction created by the inheritable contract called a driver license, and you have little say of the matter because it's either take it or leave it. And majority of you have no bargaining power to leave it. We have the power to leave it. Why? Because we have our own. And with that, I digress. I leave the floor open for questions right now. If there's any questions, please post them right now in the chat line. Once again, donations are acceptable. The Third to English Church of England or $ Clifford Jefferson L. We appreciate your free and common soakage. Once again, the floor is now open for all questions. I know there should be some questions out there. Come on with them. If there are no questions, then everyone in the chat give me a thumbs up. Everyone in the chat give me a thumbs up if there are no questions in the chat. And if there are no questions in the chat, I'm assuming in the chat that all those in the chat comprehend what's being said. That's the easy part. The hard part is remembering what I said because your status depends upon it. Remembering what's being said. Thank you, Brother Victor Thomas. Thank you, Brother Noonley. Thank you, Countess Middleton. Thank you, Brother Thomas from the House of Thomas. Thank you, Brother McGarrett from the House of McCarroll. I appreciate you very much. Once again, if there's any platforms out there that got a mass following, please, someone convey this message that this information needs to be brought forth to all of humanity to recognize that their Lord and Savior has now returned. So with that, you're welcome, Brother Noonley from the House of Noonley. You're welcome. You're very much welcome. All right. You must remember these lessons. You have to remember these lessons. It's better for you to know this than to know this and not follow it. Following it is remembering it, because if you can't remember something, how can you follow it? It's like going somewhere. If you don't remember how to get there, how are you going to get there? All right? So you must be able to follow instructions. Okay? It's better for you to not know this than to know this and not follow it, because you're going to be held more accountable for it. Yes, you were going to be held accountable. All those that listen to that email as given by Archbishop Belmont in regards to the notice of our obligation in this intellectual movement, you have been warned. Okay? So as he said, if you don't think you can live up to this, then you can leave. Okay? You can leave. All right? If you stay, you must understand. And if you understand, you must be that understanding. All right? So I love you all. And I desire the hearts back to the ways of your fathers, forefathers, and your foremothers. With that, I greet you as I greeted you, and as always, in peace and love. Archbishop, make sure you attach the template to this one. And I'll see you on the 9th with the lesson in regards to only the king has the problem to solve the what was called the port crisis. That's not the actual title, but that actual lecture will be done on the 9th. So with that, peace.